Welcome to You Counsel. If you are in a situation where you had signed up your child or children for a summer camp this summer and that summer camp has been canceled by the organizers due to COVID-19, or if you had planned a trip outside of Canada and your flight has been canceled by the airline and you are looking for the refund of monies paid to the camp provider or to the airline, how do you go about it? What are the legal principles that apply to that situation? This is the topic of our lecture today. We begin with our usual disclaimer that this lecture is not legal advice, so if you have any specific questions, you should contact a lawyer or a paralegal or the Law Society of Ontario if you are in Ontario, or another provincial law society if you are in another province or territory of Canada. This topic we will try to cover it in 5 lectures. This one is the lecture 1, and in this lecture we'll talk about the underlying principles that apply to most contract breaches. And we want to cover this because this particular circumstance of legal principles, it may apply to different scenarios, right? So we're specifically covering summer camps and flights, but it may apply to any contract that you may have entered and the other party is now breaching the contract. So the principles are fundamentally the same. You may have entered into an agreement of sale and purchase and sale of your house, and you may be having an issue where either the seller or the buyer is refusing to close and is breaching the contract. So the same principles apply. So it is important to understand the underlying principles so that if you are faced with a different breach of contract, you can apply those principles at least and understand the fundamental concepts. Obviously, this is not an exhaustive discussion, but you will understand the fundamental principles of how the law would apply in these situations. In lecture 2, which will be the next lecture, we will talk about some of the defenses to breaches of contract. So the non-performing party, what kind of defenses that party can raise to avoid liability or to avoid its obligations. In lecture 3, we will take those legal principles and then we will apply it to summer camps, and specifically we will apply it to this one particular camp called STEM camps, which is in Ontario, because we have more information about what's going on with that camp. It's in the news and there's a lot of information out in Facebook and media. So we will apply these principles to that in lecture 3. In lecture 4, we'll talk about how do you go about reversing your credit card payments when you have a dispute with the merchant, and the principles of that would apply to a large number of scenarios, but of course we will discuss that process with respect to the summer camps and STEM camps specifically. And then finally, if all fails and you have to go to court, how do you go about doing that? Now, we will explain today, the basic concepts of contract. We'll talk about what constitutes a breach of contract, and then what are the remedies for breach of contract. The concept of a contract is pretty straightforward, right? It is a transaction between 2 or more parties, and in that transaction, parties are exchanging something of value. So you pay money for merchandise, you buy groceries, you buy shoes, you buy a car, you buy a house, you pay the money and you get the merchandise, the product on the other hand. Or you pay money and you get services. You hire a lawyer, you hire an accountant, a plumber, a contractor, whatever. You pay money and in exchange, you get certain services. In our particular scenario, an airline ticket is a contract. Alex, for example, will pay $500 or a certain amount of dollars to an airline. An airline will fly Alex to Florida on a specific date. That's an example of a contract with an airline. Similarly, with respect to summer camps, Alex will pay X amount of dollars to the camp, and the camp will provide summer camp activity for Alex's child. So these are sort of the examples. All of these are basic contracts, and we know that contract doesn't have to be in writing. Ideally, a contract in writing is good, but it doesn't have to be in writing. When a party to a contract fails to perform its end of the deal, that means that party has breached the contract. It's as simple as that. So let's take an example. When an airline cancels its flight or changes the date of flight, so for example, if it says to Alex, we can't take you to Florida this June, but we'll take you to Florida in June 2021. That's sort of the fundamental, that's the breach of the contract. And in the case of summer camps, when the summer camp cancels the camp program, then they are breaching the contract. So the party that is not performing its side of the deal, that is the party that is in breach of the contract. Now, why has the party breached the contract? At this stage, it's not important. We'll talk about it later, but for now, just consider that if a party fails to perform its part of the deal, then the contract is breached. Now, why airline canceled that flight or why camp canceled, we will discuss that. It is relevant at some stage, but not at this stage. So the contract is breached. Let's understand that first. Let's talk about, once the contract is breached, let's talk about what kind of remedies does the performing party has against the non-performing parties. So fundamentally, in most contractual cases, the performing party who has not done anything wrong is entitled to damages. Now, in certain cases, they can be entitled to specific performance, but we're not going to discuss that today. We'll keep it simple. In most cases, so for example, this airline example or the summer camp example, the parties will be entitled to damages. Now, what I want you to understand is that I'm using the word damages. I'm not using the word refund of money or return of advance payment or deposit. Damages is a larger term. So your damages could exceed your refund. Damages could exceed the down payment you have made. Damages could exceed the deposit you have made. So damages is a larger term. And let me explain that by way of an example. We'll take the summer camp example to explain to you why your damages could be more than the money you have paid to the other side. So in an ordinary camp, let's take the example of STEM camp, there are certain activities that the child is going to be involved in. There is certain companionship with other children in that camp. And then, of course, there is childcare if the child is of an age that a childcare is needed. So those are sort of the automatic components of a camp. Now, if the camp provider has breached the contract, they're not providing you the camp activities, then you have to replace those activities or at least the childcare or whatever you need to do. So you will incur certain costs for replacing those things that were being performed or ought to have been performed by the summer camp. Now, so let's say the original camp cost was $500 for a week-long camp, and now you have to replace that because the other party has breached the contract, and that costs you $1,000. It could be that amount could be for childcare, could be for anything else, but replacing the activities, the function of the camp that was supposed to be provided. So in that scenario, your damages are not $500, your damages are $1,000. So they are exceeding the value of the money that you have paid or were supposed to pay for that contract. And the point is important, so I'm going to elaborate it a little bit. So in certain cases now, you will see, and it is happening already, that some people have entered into contracts for the sale of their house, right? And everything is final, all the preconditions have been met, and because of COVID-19 and uncertain circumstances, the buyer has refused to close. So in those cases, the buyer is now in breach of contract. Now you have to sell your house. So let's say your deal was for $1 million, but you have to now sell the house and you get the money for $800,000. Now you still have damages of $200,000 against the original buyer because that party breached the contract. So the application of damages has larger implication. What I want you to understand is that the remedy for breach of contract is not just the refund of your money. It could be more than that, and in specific circumstances, it could be more than the money that you have paid. Now let's recap what we have learned from this lecture. Most commercial transactions are contracts. Non-performing party is in breach of contract when they refuse to perform the contract for whatever reason. The other party is entitled to damages in most cases, and damages could be more than just the refund of the money that has been paid. Now, could the non-performing party avoid payment of damages, avoid liability? And the answer is yes. In certain circumstances, the non-performing party will be able to either not pay damages or pay less damages, and that is our topic of the next lecture, so please stay tuned, and thank you for watching.